Law Talk with Nick Marouchak. Thanks to MKI Legal, your trusted employment and family lawyers.
Nick Marouchak joins us from MKI Legal. G'day, Nick. How are you today?
G'day, Bowie. I'm great, thank you.
Cool shirt.
Thanks. Bit of flowers on it, yeah.
Flowers. I like it. Well done. Let's go straight to the phones. If you'd like to call Nick, please do. 133 882. Good morning, Rick. Is it all right? We'll get Rick up. Is he there?
He'll be there soon, yeah.
Yeah, right. We'll get Rick in just a moment. Rick's got a question about fences and next to Crown land. I think Rick's there. G'day, Rick. Simon and Nick, how you going?
Yes, look, I've got a property in Bayswater, and the back fence is actually on Crown land, which is used for trucks and cars and garbage and everything else. And someone's knocked my fence over, and they seem to say that I'm totally responsible for that. I'm just trying to find out whether that's right or not.
Yeah, so this was covered by the Dividing Fences Act. And there is actually exemption in the Act. It says basically that normally if your fence is damaged, the neighbours would have to contribute to it 50-50, provided that the damage wasn't caused by someone's negligence. But when it comes to a fence that borders Crown land, there's actually an exception. It says that the Dividing Fences Act says that if the fence adjoins Crown land and the Crown land is used for public purposes, the Crown is not required to contribute to the cost of erecting or maintaining the fence. So you have to bear the entire responsibility yourself. So it sounds like this the land next door is used for public purposes. So that would be my initial view would be that it would fall all on you, and the council was correct in saying that they're not liable. Yeah,
so it's not because it's Crown land. You think it might be up to Rick to pay for the damage.
Yeah.
Have you spoken to anybody, Rick?
Yes, I've spoken to the council and they refused to fix it. But they put bollards in there a long time ago to try and prevent people reversing in there. But it hasn't prevented them from knocking the fence over.
Yeah. So, I mean, you've tried to informally discuss it with them to see if you can get any help from them, and that hasn't worked. So it's, I think you've done the best you can. It's unfortunately an exclusion under the Act, and I just can't think of anything else unless you can prove potentially that the Crown was at fault here, like really negligent, and they would directly cause the loss. Maybe you can have an argument there. But if we're simply damaged by a storm or some third party, then it falls on you.
It's just that the bollard that they put in there, someone's knocked their bollard and the bollard has actually hit the fence.
So, Rick, who put the bollard in? You reckon the council did? What council is it?
Bayswater Shire.
Okay, and they definitely put it in, not the state government?
No, they put it in about 8-9 years ago.
Yeah, how much is the damage, you reckon?
Oh, I think it's maybe $2,000.
Yeah, all right. Rick, we here at the station, I'll put you back to Sophie and to Kira. We'll take your number, mate, and we'll give the Shire a call on your behalf. So do you think, so Rick seems to think it's on Crown land, but the Shire put the bollard in. That's a concession of responsibility, isn't it? It's like when you put a sign. I know when I used to work in the Shire of East Pilbara, we didn't put signs around water holes saying do not swim here or this is dangerous, because there's an assumed liability.
Yeah.
If they put the bollard in, that's an assumed liability, isn't it? And that might not be the proper legal term, Nick, but...
Oh, I mean, do they take responsibility for it by putting it in? Yeah, but did the bollard cause the damage to the fence?
Sounds like a truck's hit the bollard that's caused the damage, yeah.
Yeah, so here, like the driver of the truck, if you can find out who they were, you can recover the entire cost of the fence from them because they were negligent, right? So this third party is responsible.
Yep.
So that's the way you can go, but that's going to be a difficult process. You have to go and try and find the details and get information from council and stuff like that. So that's the only thing I can think of that Rick can do, because the local government still counts as the Crown.
Yeah, all right. Well, we will. So I've got Kira and Sophie have Rick's number. We'll put the call into Bayswater to see if we can help Rick there. G'day, John.
Yes, gents. Nick, I've got a question. A couple of months ago, my daughter and her friend were involved in a road accident. They were pedestrians crossing the road. The car just missed my daughter but cleaned up her friend. She was in hospital for a couple of weeks. Luckily, now she's fine. my daughter evaded any injury, but recently I just received a letter from someone from the Insurance Commission of WA saying they needed to speak to my daughter for about 45 minutes regarding her claim. We've never made any injury claim. Why would I be receiving that, and do I have to speak to this person?
Yep. So the Insurance Commission of Western Australia, we have the compulsory third-party liability. So if someone is injured as a pedestrian by a motor vehicle in Western Australia, then that would cover that pedestrian. So your daughter's friend here would hopefully be compensated by this insurance fund, and so obviously your daughter's friend, I understand, made a claim. Is that right?
I presume so. I haven't actually spoke to her mum, but yeah, I presume she has. Yes.
So if you want to support the friend, then this is what I think they're doing. They're just getting some more information in order to determine your daughter's friend's claim, right? So they're going to speak to witnesses and stuff like that. So if you want to help her out, you can. Okay. My understanding is at this stage, if you haven't been subpoenaed, if there hasn't been a subpoena or another court or another order that's given to you, like in writing saying you have to do it, then it's voluntary. So you don't have to attend the interview. You're not obliged to. Okay. But if you, but you know, assisting, it can make it easier for them. And then if you, so do you have any concerns about speaking to them? Because the only thing I'll say is if your daughter did something wrong, and she committed a criminal offence, and it sounds like I'll be very surprised that happens. She's an innocent pedestrian. Then anything you say at the interview could be used as criminal proceedings against the daughter. But that seems like a stretch to me. That doesn't seem like it's here. You know, like your daughter, like I don't see how a pedestrian could be criminally liable here.
No.
So
yeah,
that
they were
seem
just
like
there. They were just crossing the road at night time and got hit. And I mean, the police took their statements at the time, but they never got back to us either. I was just worried that they were trying to interview her to get details that maybe they were at fault to avoid, so that the driver could get off.
Where did it happen, John?
It was opposite a basketball stadium, kind of around Coburn. I think it's on Rockingham Road. Can't remember the name of the basketball stadium. It's named after a person. But
okay. Does that help, John?
And one tip I'll give is maybe if you are concerned, just ask them to give you the questions in writing first, right? So say just what would you like to discuss? Give me those questions, and that will put you probably a little bit of comfort.
Yeah, perfect. All right, thanks a lot for your help.
Thanks, John. Good on you, mate. Thanks for calling. Good morning, Rob.
Oh, good morning. Thanks for taking the call, guys. Just got a question with this wind that we've had a few weeks ago. The back fence is gone, and we've been in touch with the insurance company, and the insurance company has we paid half the excess, but they only paid for half. But with the neighbour at the back, it's making it put two letters in there, and they're just good. They say, look, so we need some help, blah, 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 but there's no one actually, no response, whatever. So I'm just wondering, how would we get hold of the surname? Because the insurance company basically says, you've got to organise, he's got to organise his half. They actually give me the cash, say it's $1,000, they give me $500 and I paid my excess. So that's half a fence, but the fence people obviously won't do the other half until someone pays them, and I don't want to pay the whole lot and then have to fight through the small claims or whatever. So just a little bit of advice would be great. Thank you very much. Yeah,
so this is the classic procedure under the Dividing Fences Act. So if you do a Google search on Dividing Fences procedure, it's pretty straightforward. The first step is you want to serve a written notice to them, to your neighbour. You want to put it in writing to describe all the facts you're relying on to get half the cost. They have 21 days to respond, or to agree or to refuse. After that 21-day period, if you don't agree, can't get an agreement, then you can go to the Magistrates Court, and then you can recover half of the entire cost of their half of the fence. So if you don't know the neighbour's name, well, you can actually do a title search, right? So you can go to Landgate, do a title search, and you'll be able to find the details of that title. So you just put the address of the property in, and you can see who the owner is. So that's just the process. If you just download there's a lot of information online, and it sounds like you're entitled to recover half of the cost. And what the insurance company did here sounds like a very standard practice. Does that help, Rob?
Google it again. What was that again, please?
Dividing Fences Act, Western Australia. There's a big handbook on there. Yeah, and you just got to follow the process, that very strict step by step. And then Magistrates Court of WA, go there. I mean, if your neighbour is properly advised, then there's not much they can do to dispute it, provided that the fence that you got is not excessive and adequate fence.
And just have 21 days.
Yeah, you have to. Yeah, 21 days. You have to after written notice. They've got. That's the time frame.
Thanks, Rob. Cheers, mate. Hope that helped. All the very best. G'day, Anton.
Hi, guys. Just phoning on behalf of my partner. She obviously separated, as a 12-year-old daughter who she has for 6 out of the 8 days a week. So 2 days, or not out of a week, out of 8 days, the father has them for 2 days. Anyway, they know he has cameras outside the house. That's been known, but it came to light last week through the daughter, saying that there were cameras inside the house, but one of those included a camera in her bedroom. So I mentioned you guys come on the radio, and I said I'd phone up, and I don't know whether that's allowed or, whatever the story is. So her father has a camera in her bedroom.
Yeah, so basically how it works is there's legislation called the Surveillance Devices Act, and that governs two things. It governs when you record audio conversations of people, and it governs when you take video recordings of people, right? Audio and visual recordings. So it's basically, when you're looking at the optical surveillance part of the legislation, it's illegal to record someone without their consent if you're recording a private activity. Right? So if you're installing cameras in the house and you're secretly recording someone in their bedroom without their knowledge or consent, that would be a breach of the Act. That would be a criminal fine. The Act says maximum up to $5,000 fine, 12 months in prison. The question is here is the daughter is the first question is the daughter's 12, right? So I know parents have cameras in the bedroom for nanny cams, right? Because we've got one for our 4-year-old son in his bedroom. Mm-hmm. So if it's not a secret camera, it's visible, then and the parent can also kind of give consent in that situation. And if the camera is visible, anyone who walks into the room that can see the camera, it's called implied consent, right? So you don't have to give express consent. You can give implied consent by your actions, which is I see the camera, I still choose to be in the room, therefore I've consented to the situation. But if the camera is hidden, cannot be seen, is not obvious, then that would be where it becomes problematic. So,
can you see it, Anton?
Yeah, so what would be the scenario if the daughter doesn't want the camera in the bedroom because obviously, she changes and does whatever she does in there and she just doesn't want it in there? Is she allowed to say she doesn't want it in there? And if she doesn't want it in there, does she have to write that down or how does she do it?
And she's 12, do you say?
She's 12 years old, yeah.
Yeah, wow. Good question. I don't know.
Yeah, so normally a
minor?
Yeah, this is something I have to answer carefully because this can intrude into so I think if the daughter says I want the camera in the room, and I think she's at the age now where you don't need a nanny cam, right? You need a nanny cam maybe when the child is young, infant, but at 12 I would be very uncomfortable with it. So then this is this situation where the daughter should say to them, to the father, I don't want it. I remove my consent. Do not record me. She can potentially even take it down. Then if the father still refuses despite the daughter's insistence, then this is where it gets tricky because a parent can give consent to their child on behalf of a child that's a minor, but this is a family court situation, right? So because you're separated, your partner can then write to them and say, look, we disagree with that, and then you can eventually go to the family court, and the family court can make a decision to take this down. So hopefully common sense prevails here, and he takes it down after it's clear that the daughter does not want to consent. Mm-hmm. And if that doesn't work, then your partner can then, Anton, take steps to go to the family court to get it removed. Does that help, mate?
Would she write a letter to him first before she goes to the family courts, or just go to the family courts? Yeah.
Like she should write it, and then the mother should also write to him. Like your partner should write to him saying, "Look, I've spoken to the daughter. She doesn't want to be recorded," and take the camera down. The other thing as well is it's obviously, and I don't even mention this, but it's clear, like if you record a child, the recording is of a sexual nature, that's highly illegal. That's completely against the law. So I'm putting that to one side because if that applies, that's a police matter, right? Mm-hmm. But if that doesn't apply, then it's a consent issue for a minor. So the steps would be, yes, your partner should write to them saying, I've spoken to the daughter. It's the daughter's wishes not to be recorded. Take the camera down, or we're going to go to the family court and have a sensible conversation to see if common sense gives way here.
Yeah. Try that, mate. Thanks, Anton. Thanks for your call. Good luck.
Thank you.
Cheers, mate. All the best. We'll come back. It's 12 minutes to 11. Last week I asked Nick to look at the notion of whether the Purcell Kelly contract could be torn up. I know Shane Love is calling for that, the Nats leader. Both Nick and I have read the recommendations from the McCusker report, and it's probably not going to be that simple. It's a bit of an open-ended contract, this one, isn't it, Nick? We'll come back in just a moment to discuss. It's not clear-cut what Purcell Kelly's, what their remit is when it comes to this crime, what they're actually supposed to be doing. Stay listening. Nick Marouchak is with us from MKI Legal. We had the earlier call about the basketball centre on Rockingham Road. Todd says it's the Wally Hagan Basketball Court on Rockingham Road, and it is a dangerous crossing, says Todd. Thank you, Todd. And Andrew's just let us know, we digress here, Nick, but Jack Robinson, the Western Australian surfer, has won the Tahiti Pro from Andrew. So I'm assuming that's part of the World Surf League, is it? Andrew, thank you, mate. I'll have a look at that on my telephone. So Jack Robinson, what a gun he is. Coming up on the show shortly is Mick Collis. Do we need a ferry service? The yes of 93 and the no's of 50. Big numbers coming in on a yes-no poll today. Last week, Nick, we were awaiting the arrival of Malcolm McCusker's report into the WA election of this year, of March of this year. You and I have both read the recommendations and the summary. Shane Love's calling for the Purcell Kelly contract to be ripped up, but it's probably not as clear-cut as we originally thought. Mr McCusker's recommendations don't paint a great picture when it comes to Treasury, the Treasurer, and the how the process was enacted. So Purcell Kelly may not be at fault here.
Yeah, that's right. With the report, McCusker basically said the real fault was inadequate staffing. So the Electoral Commission had reduced their budget. So therefore, they instead of having, say, 8,000 or 10,000 temporary electoral workers, they only requested 5,000 electoral workers. So that's what caused the problem. And Purcell Kelly, they had a contract to supply the amount of workers that the Electoral Commission asked. So they did exactly what they said. They weren't responsible for allocating the electoral workers to the polling places or training them or supervising them. They just had to supply the workers to them. So the report basically says that that's the main issue of this whole debacle. But Purcell Kelly didn't escape unscathed. So there was some criticism of them as well and how they did their job. There was some criticism of their recruitment process. So they had some experienced election staff, never actually heard back from them. They had inadequate vetting. So when they hired a lot of people, that just had no experience in electoral, and that people who had bad command of English.
Can I just read that recommendation, Nick, if that's okay? And our listeners will find this incredibly ironic, if not sad and disappointing. All temporary election workers should be interviewed to ensure they have a reasonable command of the English language and an understanding of the election process and their duties. Fair dinkum. Yeah. People working on the election who have difficulty with the language I would have thought is elections staff 101.
Yeah, there were some people that didn't know the alphabet, right? So they was the recruitment process could have been done a lot better by them, right? So, and the other thing is they also had late appointments. They were bringing in people the day before the election or very shortly before the election where they had no time for training. So definitely some criticism of them, but it wasn't their fault of the whole debacle, right? So,
seems to be the funding. Hey, reduce the funding from Treasury to WAEC, which saw a shortfall in staffing numbers required for the day. So my question, and they've got the contract for the next election, and I've always been on the record, perhaps incorrectly, that Purcell Kelly should not be the recruiters for the next election. Can the government tear the contract up as Shane Love is suggesting?
So, good question. So, the first thing, I haven't seen the contract because the report doesn't provide or attach the contract. But listener or anyone else can get the contract by making a Freedom of Information application to the WA Electoral Commission. You pay a small fee, you'll get it. They might black some stuff out. So, that's what we need to see. The first thing of this contract is basically we have to see if there's any minimum requirement that the government has to ask for staff. Because if there's no minimum requirement and the government's allowed to ask as many staff as little or as much staff as they want, they can technically ask zero. So you don't have to tear the contract up. You can just not enforce your rights or not ask for staff. So that's one option, right?
Yep.
Because when the tender came out, there wasn't any minimum requirement specified in the tender. So that could be a way around the whole issue without even terminating, is just not use their services. But then if there is some sort of minimum requirement, the contract does go for a 4-year period and there is a 2-year option. So clearly the government doesn't have to exercise their option after 2 years. Then the next question is, can you tear the contract up? So to terminate the contract, you need to basically, there has to be a good reason to terminate. I've had a look at some of the government's standard conditions when it comes to tenders, and there are certain grounds that you can terminate, right? There's provisions called event of default. So you can terminate if there's been a significant breach that cannot be fixed. So if their behaviour in the way they're recruited is serious enough, is a material breach, then that could justify a termination, right? So the question is whether this is a minor issue or a significant failure. So that's something that has to be decided.
Okay.
If they breach the contract, normally the other standard terms is 3 breaches in a 12-month period entitles the government to terminate. And there's this very general clause that should be in the contract that says in the reasonable opinion that the government's reputation has been damaged, then that's a ground to terminate as well.
And bringing the government into disrepute.
Yeah.
All right.
So there could be grounds to tear it up. Yes.
Yeah. All right. Thanks, mate. Thanks for looking into that for us, and thanks for your wisdom, and thanks for talking to our listeners today. We'll see you next week.
Thank you, Bowie.
Cheers, mate. Nick Marouchak from MKI Legal. We'll take pause.